Good evening, everybody. Welcome back for another edition of Reasonable Doubt. I'm your host, Jimmy Ardwan. As always, I have my trusty sidekick, Julio Vela, who you ran into some traffic getting over here tonight.
You know what?
And I noticed you did not do like I did. You did not wear orange like the Stros requested.
But tonight, I respectfully request the entire planet to call me Jose Altuve Julio Vela. Who hits 3 home runs in a single game?
He does.
Who does it?
He does.
3 home runs?
3. He jacked 3. I know, pretty cool.
That's amazing.
We also got with us, ladies and gentlemen, we also got our trusty friend and ally, Wade Smith. Wade.
Hey guys.
How's it going?
Glad to be back.
Well, we're glad to have you back.
Yeah.
It's been we were off last week.
We were.
It's been a long 2 weeks now.
Very long 2 weeks.
We had kind of an interesting show 2 weeks ago, I'd say. Mm-hmm. If you guys want to bring up some more questions or comments from that show that we had 2 weeks ago, I think we re-aired it last week too.
We did. We double timed it.
Yeah, so if you got anything that you want to bring up from that last show that didn't get said, please feel free to call in. 713-807-1794 is the number. I also have Twitter up at HCCLA_TV. We'll just, let's talk about this bail thing for a little bit here, because let's get back on it, because they had arguments at the Fifth Circuit this week on the bail hearing. The temporary injunction, of course, was granted by Judge Rosenthal here in Houston, ordered basically to release everybody on a PR bond that essentially should have made one. Threw the whole system into chaos. That happened earlier this summer.
I don't know if it threw it into chaos.
Well, in terms of having to release
changing it up
immediately.
It certainly made some big changes. And
then we have a hurricane on top of it.
Well, the hurricane caused its own chaos, but I don't think that the Rosenthal's decision threw it into chaos. I think it made some changes very quickly that a lot of people weren't quite prepared for.
Well, no, because she gave him 24 hours to do it.
Yeah, but they got to stay for a couple of weeks.
Well, but I mean, that's what, if you look at what the Fifth Circuit oral argument, the snippets that I saw of oral argument, the judges were questioning, like, where did she come up with the 24 hours? Why didn't she pick 48 hours? Why didn't she pick 72 hours? How did she come up with this magical 24 hours? And the argument by the county's attorneys, which they made some pretty ridiculous arguments, but they were saying that you thrust this order upon everybody to comply with it within 24 hours. And by what I mean by throwing it into chaos is, I can see their point of view on that side of the argument, that you've given now the sheriff and everybody else only 24 hours to comply with this, and you've got to start processing all these people out of jail and going through and figuring out which ones need to be let out. Otherwise, you're in violation of a court order, and you can be held in contempt. So, I mean, to that degree, I understand the argument of throwing it into chaos. What doesn't really seem to ring true with me is this whole notion of, well, we've had more people not show up for court.
And I totally agree, because here's what was happening with that. Because when that happened, I was doing a term appointment in one of the county courts, and what I saw on almost a daily basis was people who were missing court for one of a couple of reasons, neither of which was their fault. Either one, they were, and I'm sure Julio, you were
I'll
doing
chime in,
appointments,
yeah.
you'll chime in. One, they were missing court because they were getting bad information either from the jail or from pretrial services. They were being told that their court date was in a week or 2 weeks when it was in fact scheduled for the next morning.
Right.
And so they weren't showing up. Bonds were getting revoked. Judges were saying, they're not here. And they were showing up a week later, and then they were being questioned, well, where were you last week? And some judges were more sympathetic than others. And then the other reason is because, so what happens when you get released or you get given the PR bond? The computer system then says, this person's been given a PR bond and they're released. But then they have to go through processing at the jail. Well, processing can take
8 to 12 hours.
8 to 12 hours, sometimes more.
Right.
I often
a lot more.
sometimes a lot more.
16.
Yes, I've had clients that their families are asking me, when is little Johnny getting out of jail? When is he getting out of jail? And I say, look, the people who work over there get paid by the hour, not by how many people they process out of jail. So just be patient. And so what was happening is people were getting marked as being released at 7, 8, 9, 10 o'clock that night on, say, a Monday, and then they're automatically scheduled to show up in court on Tuesday morning at 8, 8:30, 9 o'clock, depending on the individual court's docket.
Now,
but then they were going through.
Are these people that have been arraigned?
So, okay.
That's my question. Because if they've been arraigned, what's the point in making them come back the next day to court?
Nothing. Conditions. Okay.
Why can't a magistrate? Why don't we allow magistrates to set conditions, though?
Agreed. Well, because every judge has their own conditions.
I know.
Well,
right? But
and it's also, Jimmy, I don't think it's within their discretion under the code.
But the judges could delegate that to them.
I suppose you're right there, but
I mean, it's just like in family court. If you have associate judges, the
temporary orders,
district judge can delegate what the associate judge can or cannot do in a case, and in federal court, the district judges delegate what the magistrate judges can do there. I mean, that to the point now, it used to not happen here in the Southern District of Texas, but recently, more and more, the district court judges here in this district are now allowing magistrate judges to actually take guilty pleas. They never used to do that.
Wow. They're not supposed to, they have no authority unless delegated to dispose of cases.
Well, they don't. So what they do is they say, they take the guilty plea and then they write a report and recommendation to the district court saying, we believe that this person has knowingly and voluntarily made an informed guilty plea, and we're recommending that the district court accept the plea. They make a written, but in terms of actually taking the plea, some of the district court judges here in the Southern District have now started delegating that, so it's not taking up their docket with a 30-minute plea hearing.
Right.
Okay, and so I mean, I'm just saying that I think that a lot of this, okay, they're supposed to show up the very next day to court, or even 7 days later. Like, what happens in 7 days? Nothing.
Well, a lot of these people need an appointed attorney.
Right.
So you do want to have them represented as soon as possible. So I think that's about half the rationale behind it.
Right, but again, these are all things that what I'm saying is they could knock a lot of this out at the magistrate level.
Oh,
they could delegate them and say the magistrates are to not only determine bond, but attach conditions. Here's our standard conditions that we want attached. Mm-hmm. We're also asking the magistrate judge to make a preliminary indication of who needs appointed counsel. We'll bring those people back to court in 7 days.
Yeah.
Because if somebody's going to hire counsel, I mean, what's the point in bringing them back?
For the viewers, if I may, because I don't know if you've been tuning in or not, but let's bring you up to speed. So Harris County was sued for violation of constitutional rights for basically people pleading to get out of jail because they could not afford bail. Harris County was sued because the allegations in the petition are that people were pleading guilty to get out of jail. The cash for bail system is unconstitutional, and poor people were pleading basically for their liberty, guilty or not, guilty or innocent. It didn't even matter.
Well, and that they were being held in jail on bonds that they could not afford, and there was never any inquiry into their actual ability to pay because there is a bond schedule, basically a list based upon the type of offense and whether or not there was criminal history.
Correct.
And the hearing officers were setting bail based on that bond schedule and not deviating from it, was the allegations.
That's correct. And in the state of Texas, a pretrial detention on, for example, misdemeanors, absent any qualified inquiry, is illegal. It's a violation of constitutional rights. So they were sued in federal court. And the federal judge said, Harris County, sorry, not going to happen anymore. anyone charged with these low-level misdemeanors, and or it applied to felonies as well, needs to be released within 24 hours
Of arrest.
of arrest.
Yeah.
And they were released. And so the panic was, oh my gosh, it's going to be Gotham City. The jails are going to open their door, and everybody inside is going to flood the city, and there's going to be crime run rampant. Well, which is still the position of the county attorneys.
Are you going to be Batman in that scenario?
It was Batman. It's Gotham City. It's straight. They thought it was going to be Batman. And for a little bit, the hysteria was it's going to be Gotham City. And you know, Liam Neeson's going to be coming around like, doing the Knights of Shadow or whatever it is, the Legion of Shadows kind of thing. But so they've released everybody. And we'll get into how that's impacted us in a second. However, what the county did is said, federal judge, you're wrong. This is absurd. We're going to appeal your ruling. And this week, they had arguments in the Fifth Circuit to appeal
Well, they asked.
the ruling.
So immediately after Judge Rosenthal entered her injunction, because this case is still ongoing. It is not over by any stretch of the means. So that was an injunction that is supposed to be temporary orders for the duration of the case. Harris County asked for a stay on that injunction. She denied that. It then went to the Fifth Circuit. They appealed the denial of the stay. The Fifth Circuit, I think, stayed it for about a week or so.
No, they denied this day as well.
And then, but then they denied it. They reviewed it for about a week, then denied it. Then they appealed again to the Supreme Court, and Clarence Thomas, within about 24 hours of getting it, denied the stay. And then now here we are back at the Fifth Circuit for the appeal.
Clarence Thomas denied the stay.
Yeah.
That's a big deal.
It was a big deal.
I mean, it's a big deal. I mean,
Why?
the man's black, and he's been completely conservative, and he rules consistently against black people. And, he made a ruling saying that, guess what? Blacks and poor people need to be out and enjoy the same rights as everyone else. I said it. It was astonishing that Clarence Thomas was the one that wrote it. I'm just
agree
saying.
with you. I mean, look, it's not a good look for the county. It's not a good look that they keep fighting this thing, that they keep losing at every turn.
Yeah, I think I read something in the Chronicle the other day.
They're spending millions in legal fees.
Yeah, their legal fees are like 4.2, and that's for outside counsel, because they have the county attorney's office that is working on this case, representing, I think.
Imagine what that 4.2 could be put to use on now in the wake of the hurricane.
Oh, yeah.
You know,
4.2 million. And we have Sylvester Turner over here saying, I'm going to raise taxes. And obviously that was fixed.
Right, and they'll never go back down.
Right.
Once you raise the taxes, they'll never go back down.
4.2 million goes a long way.
It does go a long way.
So let me ask you this, Wade.
Okay.
Has Houston turned into Gotham City because we have all these people accused of crimes on the loose?
Absolutely not. I think if anything, it's been better for the outcomes of cases. It gives everybody a chance to look into the case and see what's really going on. It has not turned into bedlam.
Have you seen, or what have you seen in the cases where individuals for low-level misdemeanors or nonviolent felonies still in custody? Because theoretically, everybody who's a nonviolent felon or who is in these little misdemeanors, they shouldn't be in jail.
Right.
Who are the people still left in jail?
The people that are still left in jail are people that are charged with. I mean, most of the misdemeanors that if it's somebody charged with a misdemeanor and they're still in, it's because it's something they've got a lot of history. Mm-hmm. They've got, and it's a violent type offense, assault, family violence. And they don't get the PR bond because they are a risk.
Some of the things that I have seen are individuals who are arrested for, let's say, evading arrest in a motor vehicle, which is a felony, and when they're finally pulled over, they get popped with the DWI.
Yeah.
And so now they have both a felony and a misdemeanor pending,
Right.
which,
So-
common sense says, why are you charging them with the misdemeanor when you have the felony? Just go on the felony.
Well,
Right.
but I mean that happens all the time. I mean, look,
It does.
and it's a plea bargaining tool,
Right.
but also it's one where on DWIs, I mean, you can't get deferred on it.
That's correct.
So they can hang that over your head, and it's kind of pick your poison. You can either be on felony deferred, or
Misdemeanor probation.
yeah,
Yeah.
Nice little felony deferred when you're subject to the full range of punishment.
If you mess up.
Woo-wee.
Yeah.
Right.
The other people who are still left in jail are people who have warrants from other counties, so they have a hold.
Right.
So even if they are released from Harris County, that other county is going to come pick them up, and that's just inefficient to send them off to another county only for them to come back to Harris. So they just keep them here until this one's resolved. Then they send them to the other county.
What's interesting I have found is, if I'm not mistaken, in Judge Rosenthal, the federal judge's original order was that no matter how many times an individual bond forfeited, they were still eligible, or they still should be released on an unsecured or PR bond. However, what we are seeing now, and it might be because the county's getting their ducks in a row and getting their numbers in order, and
Well, they've implemented the new
well,
Arnold tool.
these individuals who are bond forfeited are not getting a PR bond again. Okay, at least that's my experience.
In most courts, I have seen in a court or two that they are still getting
It is.
PR bonds.
Okay.
And I have been able to get some people who bond forfeited their PR bonds reinstated, if it was a really good reason.
But doesn't this go back to the whole discussion we had 2 weeks ago about why are we having to come to court so often? We have this all the time.
Yes. Yes.
I mean, like I said, there are so many just inefficiencies. Again, we've now expanded the number of magistrates. We're paying them a lot of money, frankly, to be a magistrate judge.
It's like 130 plus Ben.
Right. And so, I mean, look, I understand if you want to make sure a person has counsel, okay? You can knock out the appointment system through the magistrates. And if a person says they're going to hire a lawyer, okay, then say, all right, you got 2 weeks, go back, you're going to go back to the actual court, misdemeanor court or district court, wherever it is. You will show up there in 2 weeks and you're expected to have a lawyer. I mean, because really, who's going to be able to find a lawyer in 7 days?
It's tough.
There's not many people who can,
No.
okay? People who are financially able to, yes, they can probably go out and they can hire a lawyer the very next day or within 2 days. But when you're talking about, I mean, the whole reason this lawsuit exists is because poor people were being oppressed by the bail system, right?
Right.
Those people can't turn around and go hire a lawyer
Right. Well, because here's let me give you a
right
scenario.
away.
So somebody with means gets popped for DWI. They bond out. They go out the next day and they get popped for another DWI. Well, they're going to get another bond, and then they bond out again. They could do that every day that week. But you get somebody who gets popped for driving while license with a suspended license, and they can't bond out, they're stuck.
Right.
So the person with means and the person with no means are being treated differently, and that's the problem, and that's why the lawsuit happened.
Well, and they plead guilty to get out.
Right.
So what we've seen now, what I have seen now, are this group of people who would have been incarcerated pre-July 1st or August 1st or whatever, whenever that came into effect.
June, I think it was.
June 1st. These guys are out on bond now, and they have, because Judge Rosenthal said no, this is ridiculous. All these people need to be out on bond, so they're out on bond. And now, when they come in with the driver while license invalid, criminal trespass, some low-level drug offenses, marijuana.
Possession of marijuana.
Possession of marijuana.
I still get a few of
I
those.
still get a few of those too, even though they shouldn't be charged. But people get the days in certain courts of time served. 2 days, credit for 2 days, it's over.
Yeah.
4 days, credit for 2, it's done. that's over, because the scratch in the game is for those individuals who get arrested for these low-level offenses, who get arrested later in the future, in order for them to get scored, the county's taken into this tool, this 9-factor tool. They have to have had at least a minimum of 10 or 15 days on their charge for them to get points against them to count against them for PR bonds. And so now
You're talking about under the new Arnold tool.
under the new Arnold tool.
I got you.
And so now, the days of 2 days, credit for 2 days for a driving while license invalid, 4 days, credit for 2 days for driving while license invalid, 6 days, credit for 4 days for possession of marijuana. Mm-hmm. The minimum now has become 15, because the Arnold tool in their design requires at least a 15-day, so that if they ever get arrested later on in the future, they can use it against them to deny or to level them as a higher risk.
Right.
And so certain prosecutors, certain judges are taking that into account and saying, no, I'm not going to give this guy a time served. He's on bond. He has 1 day credit, and I'm not accepting any less than 15. And in the county, it's 3 for 1. And so if it's 15, he has to serve at least 5 straight, but he only has 1 day credit. All these people on bond aren't going back to jail for 3 or 4 days for some criminal trespass or for some marijuana. They're not going to do it.
Here's the good thing. So, like a driving while license suspended case, right? Where in the past they would have pled guilty in order to get out of jail.
Right.
Right? In order to get back to work, get back to their family, so they could pay their bills, whatever. Which ultimately hurt them more, because when you get a subsequent conviction for driving while license suspended, what happens, JV? You get another suspension.
You get another suspension, yeah.
Which just compounds the problem. So, but now these people are out, and most of the time it can be worked out. Hey, clear up your license, and then we'll dismiss the case. Clear up your license, get 6 months prepaid insurance, and we'll dismiss the case. So,
and that's a function of the DA's office.
It is. But if they're in jail, they can't do that. So it's been very beneficial for people like that. Or you've got your first time, your young people who get popped for possession of marijuana or something like that. You're able to do things that you used to not, if they were in custody, you wouldn't be able to do.
Right.
A dope class, community service and dismiss,
right.
or a deferred. A lot of times you weren't, or a pretrial diversion, you weren't able to do that when they were in custody.
Here's the problem, though, in the driving while license invalid cases that I see, is you put these people into a vicious cycle, because, yeah, it's all well and good that they're out and tell them to go get their license fixed. Well, one, you're dealing with DPS. That's not exactly something that can happen quickly.
No, it takes time.
It does. And your requirement is they get 6 months prepaid insurance. These are typically people who have a criminal history, a lot of driving while license invalid, maybe some other charge. 6 months prepaid insurance ain't exactly cheap.
No, it takes time.
And you're compounding this problem. Mm-hmm. I mean, you've got poor people who, if they could have afforded to get their license cleared up in the first place, we wouldn't have gotten into this problem. And now you're making onerous conditions where they have to go get 6 months prepaid insurance. It's like, wait, where are they going to come up with that money?
Do you want to know what's real silly is what these people do, and is the way that it has to be done, and it's completely absurd, is they go buy the 6 months prepaid insurance, and they take it to that court date, and they show 6 months prepaid insurance, and the case gets dismissed, and the second they leave, because they can't afford 6 months prepaid insurance, they just put in $500-600 for 6 months prepaid insurance. They call the insurance company and they cancel it, and they get their $500 back. This is the silly little game that's being played down at the courthouse. Hey, dude, look, you need 6 months prepaid insurance, clear up your license, your case will get dismissed. They come in, they buy the 6 months prepaid insurance for fun and games for that one day. Case gets dismissed, and the next day, they cancel their insurance and get their money back because they can't afford it. These people are indigent.
Right.
So they get, but this whole charade had to be played in order to gain that dismissal.
Yeah. But at least at that point, their license is eligible and their license is clear. It's not suspended anymore.
On that day. That's
on
correct.
that day. On that day.
Absolutely.
So They may not have insurance after that day if they cancel it,
But it's cleared.
but their license is clear. So
That's correct.
That's at least one thing that if they get pulled over, the most they're going to get is a Class C citation for no insurance, and they go down to the municipal court and they can either show proof of insurance or
How does that help anybody?
well, it beats being in jail.
Oh, I agree, 100%. It beats being in jail. And that's the silly game that has to be played down in the courthouse every single day.
Yeah.
I mean,
But I've not seen crime rates go up or the city go into bedlam, and like I said, the notion that more people are skipping court dates, I don't think is true. I think those numbers I think are artificially inflated by the circumstances that we had, where people were either being misinformed of when they need to report to court, or they were having to report to court at 8 or 9 o'clock in the morning, but weren't actually being physically released from the jail until 11 or 12 o'clock that afternoon.
So we're in week 3, post the courts opening back up, and kind of getting back into order here. I got to be honest. I was down there today, or no, it was yesterday, in misdemeanor court in the old family court building, and there were a lot of people who didn't show up.
I will say, there's a. I mean,
A lot of people.
and I know what you're saying.
Yeah.
But
Pre-Harvey, that was
There's a stack of every day of people who just aren't showing up.
Right, and
They're just not. I mean,
they're just not.
I see it, dude. I can't say anything different because there is the bond forfeiture pile is literally a stack of of green files.
And I understand that there's the argument, well, hey, we're post Harvey, but we're not week 3.
Yep.
At this point, it's the information's out there of where you got to go, what time you got to be there. And unless your lawyer is not doing a very good job communicating with you, you should know where to go at this point. So, I was a little bit. I mean, my client on Wednesday was able to get where he was going. Got there early, got in.
Yeah.
And we showed up, and there were a lot of people who were not there. And like you said, there was a stack.
It's just stacked like this big of
but
like
like I
bond
said,
forfeitures.
it is week 3, but it's still the first time that there's still a lot of people who haven't been to court since before Harvey.
Right.
And there's a lot of people that are still in shelters and other.
There's only one shelter left.
Yeah, but
I'm just not buying the argument on that.
There's still people who are displaced.
There may be people who are still displaced. I granted that, but that to me does not explain the number of people that I saw not in court yesterday.
There is a lot. I'll give you that, but it goes back to your point, Jimmy. Why do they need to be there? Because
I agree.
Because most of our cases, the DA's office, I mean, they're in 5 or 6 different county buildings right now. Their offices are spread out all over the city.
Yeah.
And I'm showing up on a lot of cases where the DAs haven't done anything since.
They don't even have their file. I mean,
sometimes they don't even have their file. You're right.
If I may,
And so it's very frustrating for the client.
Agreed.
I got dragged down here, especially for like a 12:30 docket. I had to leave work in the middle of the day to come down here just to sign a piece of paper. And
No, the setup is tough. Okay.
setup's very tough.
I mean, it's tough on the lawyers. Like today, for instance, you've got the Astros who started a 3 o'clock game. Mm-hmm. The Rockets are playing a preseason game tonight. The Dynamo are playing a game tonight right now. So we've got 3 events going on in downtown. You had your morning docket, you got your jail dockets in the afternoon. If somebody's coming down here, a lawyer for an afternoon docket or a bond case on docket, there were lots charging $50 to park.
Yep.
Yeah.
Today.
Yeah.
Yep.
I mean, so the lots that were open are charging between $40 and $50 to park. You've still got lots that are being taken up by construction and drying equipment, and there's no meters. All the meters are basically you can't park there because, the construction crews.
Yeah, they've got them reserved for the construction.
They got them reserved for that. So, today was a really bad day if you had to come downtown this afternoon to either represent somebody in a jail docket or represent somebody or be somebody who's on a bond docket in the afternoon. I mean, today was not good. And tomorrow is going to be probably worse because the Astros start at 1 o'clock tomorrow.
Yeah, which means that the if you have court tomorrow, show up early and park the opposite side of the courthouse from the ballpark, because those lots are going to start charging at 8 or 9 o'clock in the morning.
but the
If
problem
you
is
have an
there's no-
afternoon docket and you're on bond, you're not getting parking tomorrow.
No, but
No, take an Uber.
But the problem is, okay, you say that, so you have to park basically west of Main Street,
Right.
essentially. There's like 1 or 2 parking lots on the north
not-
side of downtown.
right, there's not a whole
There's
lot of
no
parking.
parking.
No, tomorrow's going to suck.
Tomorrow's gonna be terrible.
Yeah, because they are going to start. Those lots, because I normally park in one of those lots. At least when we were at the old courthouse, I normally parked in one of those lots over by the stadium.
Right.
And they will start. During regular season, they started their $20, $30 charging at 8 o'clock in the morning, which is insane, and it's very frustrating, but they do.
If there's one thing that I can say that I have seen, when an individual, these are post-Harvey defendants, when an individual gets their bond paperwork, it'll say, report to this court at this time, on either a green sheet, or now it's not a green sheet anymore. It's an unsecured bond paperwork.
Yeah.
The green sheets that still sometimes, if you posted a secured bond, and the white sheets if you're getting an unsecured bond, are not, and I can say this with my own eyes, are not telling you to appear at 8:30 or 12:30. They're saying appear to court at 8:30 a.m. on this day,
Regardless of the court.
regardless of the court. And so we have seen individuals who are appearing at 8:30 when their court's at noon.
You mean this is upon being released from jail?
Yes.
Yes.
Oh.
The paperwork is not being corrected. Number two, the bonding companies, some of them are, but not all of them are informing their clients who have posted secured bonds,
Right.
that they are not informing their client of where to go and or what time. It's still saying court 4 at 8:30 a.m.
Yeah.
You know, when we know court 4 is actually a 12:30 court.
Yes.
So that is a problem. So if you're getting this, if you're just getting released from jail, you're gonna have to find what time and where to go properly. Otherwise, you could suffer having your bond revoked. You can go to HCCLA.org, and I know our organization has posted those times if your bonding company and or pretrial services or whoever's releasing you isn't giving you the correct time to show up.
Yeah, and make sure it's correct. But yes, we are seeing that problem. I'm seeing that a lot. People are showing up for their court date, but their court isn't until the afternoon, and so they have one of two choices: either sit around for 3 hours, or leave and come back. And that's very
But isn't
frustrating
this
for people.
really? I mean, and look, I've heard several theories on why people are late for court. Okay, it can have everything to do with they don't have the financial means to get downtown. They have to take the bus, or they have to do this, or they're caught in traffic. Traffic's really bad. They didn't leave early enough. But at the end of the day, isn't it really about priorities and whether or not an individual prioritizes the court case and how to take care of it? I mean, look, the system sucks. All right, let's just be honest. We've talked about this. It's not fair. Okay, it's not fair that everybody has to come to court every 30 days. It's not fair the way the process goes. Yes, okay, but there isn't a taint fair clause in the Constitution. All right, there's just not. So we can sit here and bitch all day long and every week on this show about how this isn't fair and this isn't fair and it's oppressive and all that. I get it. But at the same time, all the excuses that people make and all the excuses that we as lawyers make, doesn't it really come down to one thing, and that's whether or not an adult wants to prioritize coming down to court? I mean, because look, as you as a lawyer, and here's where I get frustrated, because we all have clients who just don't take it seriously. And you as a lawyer have to sit there, you march up there, you get there on time, you walk across 5 city blocks in the sweltering Houston heat, only to have your client not show up. And you've got something worked out for them, or you're trying to get something worked out for them, and they do something so stupid as, oh, I forgot it, I didn't put it on my calendar, or I didn't leave the Woodlands early enough because I didn't think traffic would be that bad. Really? You didn't think traffic would be that bad on I-45 coming down here? I mean, it's just one excuse after another sometimes with some people. Some people are better about it than others, but the reality is some people just don't give a crap. They just don't.
I've seen it, man. And I had a client the other day.
You know, and as much as we want to try and change it, I mean, I think that's the reality. I mean, and I think that's what the judges see. The judges see people who just don't give a crap.
Well, there are those people.
There's a lot of those people.
I've had them as clients.
There's a lot of those people that just don't give a crap, and they give 2 middle fingers to the system and say, I'll come when I want, I won't come when I want.
The problem lies, though, in that sometimes judges treat everybody who is late the same way as someone who didn't prioritize.
Well, but isn't that what we do in this country all the time, Wade? Look at what happened in Vegas.
Yeah.
One maniac goes up, busts out some windows, buys a bump stock, and takes out 60 people and injures 500 more. And people like me who like guns and like to shoot guns and shoot them responsibly, people are looking at us like we're the bad guys.
Right.
So that's what we do across this entire country. So I don't blame the judges for painting everybody with a broad brush, because there's a significant portion of the people that are charged in this county that just give them 2 middle fingers and say, we aren't going to play by your rules. They do it to their lawyers too. A lawyer calls them up, sends them a letter, says, you need to be here by this date. Turn off your social media. Don't do anything stupid so that I can help get this case resolved. And they go, we're not going to do that. We're just going to do whatever the hell we want. So, I mean, I get it. I get where the judges are coming from to some degree on this.
Sure, absolutely. I'm not saying it's not valid.
Because that's what we do in this country. We just take the worst people that are out there, and we paint everybody with that broad brush. And frankly, I'm sick of it.
Agreed. You know,
But I can understand it. I mean, look, the people say, again, you know, whatever argument, side of the argument you're on, you're going to take the worst of the worst, and you're going to paint that entire group with that. So I don't have a problem, you know, with the way the judges act on some of these issues sometimes, frankly, because they've seen a lot, especially the ones that have been around for years.
But they should prevent themselves from being jaded, and they should take a look at each case individually.
Agreed.
And that's the problem, is when they don't do that and they just say...
Well, but it's hard to when you've seen it repeatedly, especially some of the judges have been over the years.
But they have to resist that urge. That's part of their job.
I know.
Is to be impartial and to be fair.
Right.
And if they're not going to be impartial and they're not going to be fair, then...
That's all well and good, but we're all human too.
Right, and they have to understand that.
Let's get a phone call in here. Hello, welcome to Reasonable Doubt. Thanks for calling.
Hi, thank you for taking my call. I am a criminal defense lawyer, and I've been listening to your discussion about judges can't help but paint everybody with a broad brush, and some clients are just stupid and don't care about showing up. I guess I'd agree with Wade. Judges are paid the money that they're paid for the position that they're put in to be impartial. And as a lawyer, I feel that sometimes I am representing someone who's probably not going through the best time in their life and is making mistakes. Otherwise, there would be no point for me to represent them, because they would have had all of their things together and been acting like a perfect, productive person in society. So I think that it's dangerous when we start saying that because a few clients are so bad, everyone is bad. And then I'd like to comment on the bail lawsuit. In my experience, as soon as the injunction went into place, I had homeless clients who were showing up for court after being released. In some cases, I didn't even have phone numbers for them, and I bought into this mentality that was put forth by the pretrial services department and by the judges that these people were just not going to show up. We don't know how to find them. before the injunction, they couldn't even get a bond or a PR bond if they couldn't verify an address, which I think is atrocious. And all of my clients after the injunction, all of the homeless ones, showed up for court, dressed appropriately, and I felt bad that I bought into that ideology. So I'd like to say that I think the bail lawsuit has been a good thing. And one last comment I'd like to make on the post-Harvey confusion and some clients not showing up for court. Initially, they sent out a mass email saying that, at least as I recall, everybody's case would be reset for 2 weeks from the original date. And I told all my clients that same information. And then later, all my appointed cases were arbitrarily reset to dates I had no idea about. So I think that added perhaps to some of the confusion and some clients not showing up. Some people were displaced, living out of motels. I have clients that are still living out of motels and don't have their cell phones. So I think that's probably been a contributing factor to those who maybe don't show up. But all in all, in my experience, I think everybody that I represent has shown up. So anyway, thank you for allowing me to comment.
You bet. Thanks for calling.
You got to get some of that Trump money.
Well, I mean, look,
Trump money.
I think the caller's point kind of helped my point a little bit. Because if a homeless person can make it to court, why can't some of these other people?
You know, I have, so there was a client, you know, a couple weeks back. I'm going to be real vague. It's not my client anymore. But,
You finally got tired of it.
no, because the case is over, but it had to be over. It was put to bed by the judge, basically. So this girl had bond forfeited pre-Harvey, showed up to court pre-Harvey. Post-Harvey comes to court. Post-Harvey, bond forfeits again. Post-Harvey shows up to court. And at that point, the judge was like, or was arrested and brought back. At that point, the judge was like, nah, I'm done with, like, you can't prioritize coming to court as something that's a serious matter. I'm done. I'm just done with you. I've bond forfeited you twice. You showed up to court after I was like begging her, you need to come to court. And she's telling me, you know, that I can't go because of her own personal circumstance or whatnot. And so I said, look, they're either going to issue a warrant for your court or we can just come to court and you can just beg the judge to not forfeit your bond. Well, she took my advice and, you know, came to court and open court and begged the judge not to forfeit her bond about 4 hours after docket call. And the judge said, you're not prioritizing this in your life. This case is over now. Well, I mean, you have your own decision, but guess what? I'm revoking your bond and you can go figure it out in jail or we can figure something out right now. And I felt what you were feeling in the sense that he or she wasn't taking the case seriously. Mm-hmm. And it was a case that I'd been attached to early on, pre-Harvey. I'm in courts past that court. I don't even have any cases in that court anymore at the current moment, but I'm having to go back because this person isn't showing up to court. And it's not because she was in the hospital, it's not because she was in a wreck, it's just because the old person won't come to court. And so the judge had finally had enough and called it. And I'm with you, Jimmy, in the sense that she was given fingers to the court saying, and to the system saying, screw you, I got better things to do with my life. And at that point, the judge said, no, you don't. This has to be a priority in your life. Yeah. However, I did feel that on the flip side, that all we've been doing, I haven't even worked on her case. We've just been going back and forth with the DAs and the judge for about 6 months, pre-Harvey and post-Harvey, about whether she's going to show up to court or not.
Yeah.
Her guilt or innocence about showing up it hasn't even come into play.
Can I ask you a question?
But now, yes, but in a second.
Sure.
But now, because she's been forced to come to court, the person had to make a decision on guilt or innocence, not based on whether they were guilty or not, but based on whether or not they were going to go to jail that day but in reality, it was whether or not the judge felt that she was taking her case serious enough.
Right.
Which is a different consideration altogether. So if she didn't have to, if she hadn't have been able to show, she hadn't been required to show up to court all these different times, she may, or this person very well may have ended up in a very different position, and we would have gone to trial and fought her case.
Right. So were her bond forfeitures based on just not showing up for court, or for some other reason?
They were for not showing up to court.
Okay. So, and like you said, there was really nothing going on that she necessarily needed to be there for. No contested hearing.
Right, correct.
Nothing like that.
We couldn't even start to get into the merits of the case.
Yeah.
For the last 6 months.
You know, a couple of weeks ago, a much older, much wiser attorney said this. He said, you know, courtrooms are not a place meant to be meeting with clients. They are not a place to be receiving and picking up discovery. They are not a place to be discussing the case with the DAs necessarily.
No, they're not.
The courtroom is meant for trials and hearings. And yet on a daily basis, we use them for everything but. And, you know, it kind of goes back to that whole idea of, and I think y'all talked about it on the show a couple of weeks ago, about waiving clients' or having a scheduling order or something where the client doesn't have to be there. Nobody has to show up every 30 days, which would allow attorneys more time to do lawyer work, actually practice law, working on cases, going through discovery, as opposed to showing up to court just to sign a reset. I think that's a much more, you know, they do it in the federal system,
look,
they do it in the civil
court,
system.
everything. I mean, look, everybody, that's what I'm saying, everybody agrees. Everybody on this side, and now the DA's office, everybody agrees, okay? I think they're even, I mean, look, Ryan Patrick did scheduling orders. I mean, I think you're going to see some other judges doing scheduling orders. I don't know that for sure, but I mean, I would venture a guess that some others are going to do it, because when Ryan Patrick did his, guess what? It didn't all fall apart.
The cases that needed to be tried were tried.
But
Cases that weren't, didn't.
but here's my point, okay? We all agree that's what needs to be done. And I'm not saying that's not what needs to be done. In fact, I'm always here advocating that that's the course that needs to be done. People don't need to be coming to court every 30 days. Stuff doesn't get done. Just like you're saying, Julio, the sole reason she got her bond forfeited was for not coming to court. But if we had had a system where she didn't have to come to court, she wouldn't be in that predicament. But my point is, think about it, each of you guys. How many times have you had to do something that in order to obtain a certain result that you wanted to get, you had to play by somebody's set of rules? You didn't like it.
Pretty much every day, don't we?
Yeah, we
How many times has that happened throughout your life?
A lot.
As a kid, going through high school, going through college. I mean, there are certain things, it's like, why am I having to do this? Why am I having to jump through all these hoops when I don't need to do X, Y, and Z to get there? And maybe everybody's like, yeah, you're right, but that's just the way it is, okay? And that's always the argument that we hear in Harris County. Well, why don't we have scheduling orders? Well, that's just the way it is. I mean, there's no real thought to it. It's just, you know, well, that's just the way it is. Okay? All right, but that's the current system we operate under, okay? And we can sit here and we can be advocates for it all, to change it all day long. But until it changes, the clients have to realize that they have to play by those rules.
Right.
The lawyers have to realize, and I think most of the lawyers do, that we have to play by those rules.
Sure, and I've told
arbitrary
clients
rules.
the very same things that you're talking about right now. I've told clients, I've said, look, this is the most important thing going on in your life right now.
Yeah.
It has to be, because if it's not, everything else is going to go away.
That's right.
Potentially.
You don't need a car when you're in prison.
Yeah.
You don't need a home when you're in prison.
You don't need a car.
You don't need a car. I mean,
You don't need a job.
I mean,
you don't need the house.
Well, they'll give you a job. They'll give you a job in prison.
They'll give you a job in
It
prison.
won't pay very well, and it's not going to be one you want.
So if you like your house and you like your car, show up to court.
Yeah.
Yeah.
Don't piss dirty, because they're going to use these arcane rules, which in my own personal opinion, and on this show, and when we go afterwards and hang out, I scream to high heaven that they're violations of constitutional rights. It is a sham of justice.
A travesty mockery.
But you're darn right. I'm telling my client, show up to court at 8. It's at 8:30, but you show up at 8. Like, you're darn right, because we have to play by those rules until and if something changes. But I won't pretend either that we have to play by the rules while this power structure, this ideology is in place.
Right.
We have to.
And there is a court or two that are doing things a little differently, that are allowing clients' appearances to be waived when there's nothing going on a somewhat limited basis, but they are allowing it to happen. And, you know, we've got some judges that are retiring, and a lot of judges that are being contested in their bench for the next election cycle. So it's foreseeable that we may have some new people on the bench. We're at least going to have the ones who are retiring. We're at least going to have new people on those benches, and then maybe some other ones that are new, depending on how the elections go. And you know, I've talked to some of the candidates, and some of them have some different ideas about things, and some of them not so much. And I mean, it's possible that there could be some changes on an individual basis coming, which makes it a little confusing for some clients because.
But I mean, look, each judge does things the way they want. They have the power. They're the judge, right?
Right.
They make the rules.
Right.
Again, there's nothing that says you have to come to court every day, and there's nothing that says you don't have to come to court every day, except the person in the black robe. That's it. And every judge sets forth, whether it's a federal judge, a state court judge, district court judge, a misdemeanor felony judge, family court judge, civil judge, a municipal judge. What they say of how things are supposed to go is the law for that courtroom. And if one judge says, hey, you know, I'm doing scheduling orders and I'm having these hearings on this day, we're starting trials on this day, and we're doing pleas on this day, that's how it's going to run.
Yeah.
You know, each judge sets their own courtroom.
They absolutely have the discretion to run their courtroom, you know.
It's just that what's happened here in Harris County is that the majority of the judges, and historically all of the judges, have decided they're going to run everything pretty much uniformly.
Right.
Instead of each one having their own. Now each judge has their own
Quirks.
Idiosyncrasies
where
and stuff.
you know, certain things need to be done before a plea will be taken, or this, that, and the other. But in terms of how the day is structured, you know, starting court at 9 o'clock, and we're going to have this mass of humanity coming into the building at the same time.
Yep.
Yeah, that's just the way
they
all kind of got together and decided this is the way it's going to be.
What do y'all think of the argument that if we don't have them show up to court every single time, nothing's going to get done?
Look, I can see it. Okay, I understand where they're coming from, because it forces people to have at least. I can see the argument that it forces people to have some sort of accountability. It forces the clients to have some sort of accountability to show up on time. Okay, to know that this is a serious process that you're going through. Again, it goes back to the whole, if they're not taking it seriously to make a court appearance, how do we know that they're going to take it seriously to put them on probation?
The theory being it keeps it from turning into an out of sight, out of mind.
Correct.
thing.
And I think that there is, probably justifiably so, some belief, and again, I think it's a justifiable belief that there are those on the defense bar and the prosecutor side that you don't make them come to court all the time and make them do things with a file where there's somebody cracking the whip. They're not going to do anything.
You're talking about the lawyers.
The lawyers.
Yeah.
And look, there's a bunch of lazy lawyers out there.
There's a lot of lazy lawyers out there.
Okay? And so I think
I count on them.
but
I count on them. Yeah, that's fine.
I think that's a legitimate concern.
Yeah.
I think that's a legitimate concern. The judges see lazy, unprepared lawyers every day. And unless somebody is lighting a fire under their ass, nothing's going to happen.
And until a judge says, we're going to go ahead and try this one, it's trial.
Right.
It's trial. Trial is the only thing
That gets people moving.
that gets people moving. You're up.
Right.
Okay, this case is going to go away. This case is going to do. It's trial. And I mean, it's trial.
Yeah, well, at that point, there's the game of chicken ends.
Yeah.
Right.
Let's try and grab another phone call here before we get off the air. Hello. Thanks for calling Reasonable Doubt.
Hey, y'all. That's Justin. Do you think there's another way to hold attorneys accountable for not working between court appearances other than making defendants show up?
Trial.
They're officers of the court.
Trial.
Trial aside, judges have ways of holding attorneys accountable without making defendants show up.
Well,
right?
the only thing I think they could do is not something that everybody wants to hear, but they could start sanctioning lawyers.
Sanctioning and contempt.
But we've seen that movie play out before.
Well, status conferences where they make the lawyers show up and the defendant's not necessary, and the judge
Right.
can say, hey, what's going on?
But I mean, in terms of the accountability for someone being lazy, I mean, look, the only accountability is this, and they're never, at least they're never going to do it to the state or the government. Okay. The thing they could do is say, you don't have your act together, your exhibits aren't coming in.
Yeah.
Yeah.
Okay.
You're about to get rolled in trial.
Yeah. If you don't have your exhibits turned over, you don't have all your discovery turned over, if you haven't turned it over by this date, you don't get to use it.
Yeah.
But that never happens.
It doesn't
And
happen.
It's gonna take the robe to hold both sides accountable. To have the guts to say, I'm gonna sign this motion to dismiss. I just read I think it was in the Chronicle or somewhere about some judge in the Valley in Cameron County. The headline was, "Judge dismisses case for cop who got a DWI and refiled as a obstruction of justice or some shit." And when you read the article, it's like, no, it was upon motion of the DA. Like, the DA didn't get any flack. It was the judge who got it. So it's those judges who have the guts to say, look, I'm holding both of y'all accountable, and I'm gonna stick to that. And I don't know if, we have some, but,
We don't have enough.
we don't have enough.
That's all the time we got, ladies and gentlemen, for tonight. Wade, we appreciate you coming on and ranting with us for an hour.
I enjoyed it. It was
It was a
fun.
good time. It
Getting
was a
our
good time.
opinions
Thanks
out.
for having me. Always enjoy being
This
here.
was a total rant fest.
We haven't had a good old-fashioned rant fest in a while.
But we made up for it tonight.
I agree.
We are off next week, ladies and gentlemen, but we'll be back in 2 weeks with another episode of Reasonable Doubt. Go like us on Facebook and follow us on Twitter to keep up with what's going on the show. We'll try and update you with any guests and topics we will be covering. But that's all the time we have for tonight. For Julio Vela and Wade Smith, we'll see you in a couple weeks, everybody. Good night.
Go Astros.
Go Stros and horns.